1659DS. In each of these matters, Mr. Adam is here today after failing to appear before referee Nets on November 6th, 2020. In the 2009 case, bond is currently set at $1,009. This is the 8th bench warrant. In the 2012 case, bond is currently $935, and this is the 5th bench warrant. And in the 2019 case, bond is currently $500, and this is the 1st bench warrant. He reports no employment. The last payment made on these accounts was in May of 2024. Front of the court recommends that reasonable bonds be set in these matters and they be scheduled for hearing on July 31st, 2024 at 8 o'clock a.m. before this court.
Thank you. Mr. Adam, you're before the court charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on July 31st, 2024 at 8 o'clock a.m. You will get notice of that in writing. Are you able to post a bond, sir?
No, sir. Everything been going a little bad for me right now for my baby mama. Like, for like my mail and all that, she ain't been telling me about my mail, you know, because we've been into it. So a lot of things, it's hard to explain, man. I wish I can tell y'all more and y'all can understand where I'm coming from.
Okay, well, you're going to have to work out something better with your mail, it looks like.
I know.
Well, what I'm going to do is on these cases, I do note you have 8 prior bench warrants in the one case. On your 2009 case, I'm going to set your bond in the amount of $500. And on the 2 other cases, I'll set your bond in the amount of $200. If you're able to post that, you'd be able to be released. Do you have any questions?
Well, you know how many days I'm staying into?
Well, you'll be there until the 31st when we have your hearing.
31st of what?
Excuse me?
What day of the 31st?
Okay, you haven't been listening to anything we've said, I guess. 31st of
okay.
July. July 31st, 2024 at 8 o'clock a.m.
Okay. Yeah, I have hearing problems. I'm sorry. I don't mean to be like that.
Okay. Well, you're free to go. Have a good day.
All right.
Ms. Adams is here today after failing to appear before referee Courteau on November 18th, 2022. Bond is currently set at $1,062, and this is the 1st bench warrant. She reports no employment. There have been no payments made on this account. Front of the court recommends that a reasonable bond be set on this matter and it be scheduled for hearing on July 31st, 2024 at 8 o'clock a.m. before this court.
Ms. Adams, you're before the court charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on July 31st, 2024 at 8 o'clock a.m. You will get notice of that in writing. Are you able to post a bond, ma'am?
No.
Okay. Well, I do note it's your 1st bench warrant, but I also note that you've not made any payments in this particular case. So what I'm going to do is I'm going to set your bond in this matter in the amount of $200. If you're able to post that, you'd be able to be released. Do you have any questions?
No.
Okay. Thank you. You're free to go. Have a good day.
All right. We have one question.
Yeah.
How long will I have to do if I'm sure I can get that paid?
If you can't post the bond, then you'll be there until the 31st when we have your hearing.
Okay.
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 Thank you.
You're welcome.
Anything else, Mr. Chapman?
Ms. Pan is here today after failing to appear before this court on November 9th, 2022. Bond is currently set at $3,520. This is the 2nd bench warrant. She reports that she is employed at Surrey Home. Last payment made on this account was in August of 2022. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on July 31st, 2024 at 8 o'clock a.m. before this court.
Ms. Pan, you're before the court charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your tenants at the next hearing on July 31st, 2024 at 8:00 a.m. You will get notice of that in writing. Are you able to post a bond, ma'am?
I mean, I can probably get my dad to help me with one. I don't know how much, but probably. I hope.
Okay. Well, what I'm going to do is I do note that you have a sizable arrearage.
Yes,
And you
I
haven't-
just started working
Okay. You haven't paid in a year.
Sunday and called the day that I got, yeah, because I was a drug addict, so I wasn't working, I was doing drugs.
Okay.
I'm sober now. I got off of, I was going to the methadone clinic and I haven't done any even methadone or anything since Memorial Day. So I just got my job, started Sunday, and then got arrested Monday leaving work. But I just called Monday actually to try to set up a payment plan to take care of my warrant like hours before I got arrested, but I had to leave a message.
Okay. Well, what I'm going to do is I am going to reduce your bond in hopes that you could be released. I'm going to set your bond in the amount of $500. If you're able to post that, you'd be able to be released. Do you have any questions?
So how long am I going to have to stay in here? Because I'm not going to be able to pay that amount.
You'll have to stay there until the 31st when you have your hearing.
Okay,
Okay. You're free to go. Have a good day.
thank you.
04DS. Mr. LaForge is here today after failing to appear before this court on May 1st, 2024. For the record, that was a bench warrant hearing. Mr. LaForge was previously before the court for a bond review hearing on April 24th of 2024. He was given a $500 bond, which he posted and then failed to appear for the hearing. Bond is currently set at $9,453. This is the 6th bench warrant. He reports no employment. Last payment made on this account was the bond forfeiture, and that was in May of 2024. Front of the court recommends that a reasonable bond be set on this matter and it be scheduled for hearing on July 31st, 2024 at 8:45 a.m. before this court.
Mr. LaForge, you're before the court charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your tenants at the next hearing on July 31st, 2024 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
No, sir.
Okay. Well, court notes that you do have a considerable arrearage, and obviously you didn't show the last time when the court gave you a reasonable bond. What I'm going to do this time, I'm going to set your bond in the amount of $1,500. If you're able to post that, you'd be able to be released. Do you have any questions?
No, sir.
Okay, thank you. You're free to go. Have a good day.
That's all I have for today, Your Honor.
Okay, thank you. Good morning to both of you. Mr. Connor, I'm going to start with you. I do note you have not approved the judgment. Are you disputing or contesting anything in this case?
I'm not disputing or contesting anything.
Okay.
Like, everything in the judgment is cool. Like, I've already went over it.
Okay.
I've discussed it with Amber. We came to an agreement on what's in the judgment.
Okay, thank you. Ms. Connor, what we're going to do is take some testimony from you. So if you would raise your right hand, we'll have you sworn in, then we'll proceed.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
I do.
And Ms. Connor, you can go through the script that we would have provided you. You don't have to disclose your address if you don't want to, though.
Okay. You want me to read it now?
Yes, go ahead.
My spouse and I were married on May 10th of 2016 in Battle Creek, Michigan, by a person duly authorized to perform marriages. I was a resident of the state of Michigan for at least 180 days, of Calhoun County for at least 10 days prior to filing the complaint for divorce now before the court. The allegations and complaint were true when I filed it and still true today. My spouse and I ceased living together as husband and wife on December 1st of 2021. There are one minor child born of the marriage, and Amber is not pregnant. There has been a breakdown of the marriage relationship to the extent that the bonds of matrimony has been destroyed, and there remains no reasonable likelihood that the marriage can be preserved. If the court were not to grant a judgment of divorce, I would not resume a marital relationship with my spouse. I wish to have my maiden former name of Sayre to restore to me. And the reason for the breakdown of the marriage is we just had too many disagreement and went our separate ways.
Okay, thank you. Court will find that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. The file does appear to be in order, and the defendant has appeared stating he does not contest or dispute anything. As a result, the court will, and I have signed the judgment. You are divorced. Best of luck to both of you. I hope everything works out. You're free to go. Have a good day.
Thank you, you too.
All right, thank you. Let's move on to our next at 8:51 a.m.
Oh, I'm good to leave.
Good morning to both of you. I'll go to you first, Mr. Inman. I'm looking at the proposed judgment of divorce. It has what purports to be your signature. Did you sign that, sir?
Yes, sir, I did.
Okay. So you're not disputing and you're not contesting anything, correct?
Not the ones that we sent in, nope.
Okay. Ms. Inman, we're going to take some testimony from you. So if you would raise your right hand, we'll have you sworn in, then we'll proceed.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
And Ms. Inman, you can go through the script we provided you, but you don't have to disclose your address if you don't want to.
Okay. My spouse and I were married on July 12th, 2020 in Fayetteville, North Carolina by a person duly authorized to perform marriages. I was a resident of the state of Michigan for at least 180 days and of Calhoun County for at least 10 days prior to filling out the complaint for divorce now before the court. The allegations in the complaint were true when I filed and are still true today. My spouse and I ceased living together as husband and wife on January 9th, 2024. There are 2 minor children born of this marriage, and wife is not pregnant. There has been a breakdown of the marriage relationship to the extent that bonds of matrimony have been destroyed, and there remains no reasonable likelihood that the marriage can be preserved. If the court were not to grant a judgment of divorce, I would not resume a marital relationship with my spouse. I wish to have my former name of Williams restored to me. The reason for breakdown of marriage is a mutual agreement.
I'm looking at the proposed judgment. You did not put the provision in that you wanted your name changed. So what do you have a middle name, and do you want to keep your middle name?
Yeah, I want to keep my middle name.
Of course, I'll change that. I'll change that paragraph. And hold on. Okay, I made that correction. Court will note that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. Again, with that correction to the judgment, I have now signed the judgment. You are divorced. Best of luck to both of you. I hope everything works out, and you're free to go and have a good day.
Thank you.
All right, 8:56 a.m.
Good morning to both of you. This matter is before the court for a scheduling conference. At the scheduling conference, we set it in place various dates and also processes so that the case would proceed in an orderly fashion. But I need to know first, I'll go to you, Ms. Slate. What issues do you believe to be in dispute in the case?
There are no issues in dispute that I'm aware of.
Okay. Mr. Slate, is that your understanding, is you've come to an agreement and you're not fighting about anything?
That's correct.
Okay. Well, what I'm going to do then, I'm not going to put in place a scheduling order. And the reason I'm not going to do that is it kicks into place a mediation process, and there's a cost associated with that. I don't want you to incur that if you have come to an agreement. Ms. Slade, what you're going to have to do is you're going to have to prepare a proposed judgment of divorce, a uniform child support order, and a judgment information form. And you're going to have to prepare those 3 documents submit those to Mr. Slate for his approval. And if you get his approval, then submit them to the front of the court. They have to approve those. And then all we have to do is wait for the running of the time frame, and we can get the matter complete.
Okay.
So I don't know if you've used some sort of a service or whatever, but MichiganLegalHelp.org has all of those forms online, and you can go through and just fill in the blanks on things and get them done.
Okay.
Okay? Any questions, Ms. Slade?
No, I don't think so.
Mr. Slade?
I'm good, Your Honor.
Okay. What we're gonna do is I'm gonna reset this for about 60 days. And that way, otherwise we'll lose track of it. And Ms. Slade, in the meantime, you can prepare the judgment, the Uniform Child Support Order, and the judgment information form, get those documents prepared, submitted to Mr. Slade and to the front of the court. And then hopefully when we come back, we'll have all of that stuff done and completed, and then we can progress, get the case concluded.
Okay.
Okay?
All right.
Thank you. You're free to go. Have a good day.
Thanks, you too.
All right, thank you. We'll close the record. Is this Courtney Smith?
Yes, sir.
Yeah, we're ready for you.
Thank you.
Mr. Smith, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. Do you understand the charges?
Yes, sir.
Court would advise you have a right to an attorney. The court would appoint an attorney to represent you should you desire an attorney. To my understanding, you wish to proceed without an attorney. Is that correct?
Yes, sir, please.
Are you doing so freely and voluntarily?
Yes, sir.
Has
Your Honor.
anyone threatened you, coerced you, used any undue influence, pressure, or promises to get you to appear without an attorney?
No, sir.
Okay. Court will find that Mr. Smith does freely and voluntarily waive his right to an attorney. Mr. Smith, before we proceed, I'm going to have you and Ms. Mouton raise your
Yes,
right
sir.
hands. Okay. Thank you, Ms. Mouton. You can proceed.
Thank you. Your Honor, before the court is Courtney Smith. He has dockets 2013 Smith versus Harvey and docket 2022 with Rob versus Smith. In the 2013 docket, Mr. Smith is before the court for a bench warrant hearing because he failed to appear for an adjourned show cause hearing, an adjourned compliance hearing on May 29th, 2024 before your honor. He's currently ordered to pay $201 for current support, $87 towards arrears for a total monthly obligation of $291.50, including service and processing fees. Last payment received on this docket was on May 10th, 2023 in the amount of $105.53, and we received that through income withholding. This is his second show cause, fourth bench warrant, and Mr. Smith has had no previous findings of contempt. I measured his compliance over the last 3 months. He should have paid $874.50. He has paid nothing. Shortfall at the time of the adjourned compliance hearing was $2,332, giving him a total shortfall of $3,206.50. Total arrears due through June 30th, 2024 are $3,106.81. And the 2022 docket, Mr. Smith is currently ordered to pay $553 for current support. Arrears are $133 per guideline for a total monthly obligation of $689.50, including service and processing fees. Last payment received on this docket was on May 10th, 2023 in the amount of $290.33, and that came through income withholding. This is his first show cause hearing. This is the third bench warrant, and he's had no previous findings of contempt. I measure compliance over the last 3 months. He should have paid $2,068.50. He's paid nothing. Shortfall at the time of the adjourned compliance hearing was $5,252, giving him a total shortfall of $7,320.50. Total arrears on this docket are $7,188.39 through June 30th, 2024. Mr. Smith did book into Calhoun County Jail on July 10th, so he would have credit for 14 days. And on his March 27, 2024 bench warrant hearing Friend of the court did request, and it was ordered that Mr. Smith be ordered to participate in the LEAP program, now GEMS program. A support review was ordered. A case questionnaire was sent to Mr. Smith, and he failed to participate in either one of those.
Okay. Mr. Smith, do you dispute or contest any of the statements made by Ms. Mouton?
No, I don't, but may I say something, please?
In a minute. Do you have any
Okay.
questions for Ms. Mouton?
No. Yes, I do,
Okay.
Ms. Mouton. If I was to, yes, I do, but can I go?
Okay, hold on. Don't keep stepping on what I'm trying to say. Just
I
wait a
didn't mean
minute.
to, I'm sorry.
And then you'll have a chance and I won't interrupt you. What would you like to say now?
Okay, I just want to know if I did get like released today, what I have to do, or any day, what when I do get released, what do I have to do? Do I come straight to like the because I've never really dealt with, I know my kids are almost 18. Well, my other kids are almost 18 and I've never had a problem. I've never been to jail. I've never not paid. It's this last time has just messed me up a little bit and messed me up in my head, and I haven't been all there. And I'm wondering, like, what do I do when I get out is all I need to know from you guys today. Like, when I get out, what do I do? Do I go?
What you have to do is you have to pay your support pursuant to the support orders.
No, 100%. 100%. I'm just saying, like, to get it, like, because I don't have a job or nothing, and because I haven't, I'm trying to get a job. I got applications out there like crazy right now, and I'm just wondering, like, what do I do to like get it? Like, is there a way to the program that I had to participate in last time? When I called them, they said I had to be because I called them, they said I had to be requested by you guys, and I said okay, and then I didn't know what to do after that. I thought I already was requested by you guys.
Well,
and then
probably
like
were.
the program.
When you were ordered into the GEMS program,
Yes.
what happened is obviously it takes a period of time. I don't like, let's say for instance today, if you got out after this hearing and you called them, they wouldn't have the order yet. It would probably take you a couple days for them to get.
That's what happened.
So what happens is you have to wait that couple days, and if they still don't have it, call them back until such time as they confirm that.
Yes, sir.
Okay. You said you have some applications out. How many applications?
I have. Sorry, sir.
How many applications would you say you've put in the last 6 months?
I have put in over 40 applications, and I have proof of it all too. I have it. It's all on Indeed. And I'm also through on staff, and I've already went and took my drug test and everything to them. I was just waiting to hear back from them, and I'm through another temp agency, but it's online, and I don't know exactly what they're called right now.
Okay.
But I do have proof of it all. I can bring this Mouton, I could bring it to her today even. I have proof of it all. I have sent everywhere, and I promise you guys, I wasn't just like sitting duck out there. I was trying my best. And I did call the LEAP program. Like I said, I didn't know I should have waited a couple days, but they told me that I had to be referred by you guys. That was my fault. I'm not getting with Miss Mouton and asking why I wasn't referred there. That was all me. That was my fault. That was my doing, and I apologize, sir. But I'm not the one to not pay child support like this. I try to take care of mine. And my son just got hit by a car on 7/19, and I don't even know the condition that he's in or anything right now, and it's like killing me because I can't, in contact with anybody. But he got hit by a car on 7/19. Jaden Smith did, and yeah, I'm just trying to figure out. I just get my life in order, man. Pretty much. When I get out of here, I plan on moving in with my brother. I'm still staying at this pretty much abandoned apartment with my dogs, and I'm about to get rid of my dogs and everything. As soon as I walk out this door, I'm getting rid of my dogs. I'm moving in with my brother. I'm going to keep continuing to try to pay what I can. I'm going to try to pay anything that I can. I think I got like $100 at home. That's about the most I got right now. And I promise you that I will be on a job, and I will show Miss Mouton daily if need be that I will. I'm out here looking, and I will put in everywhere. I'm talking out just beside the factories. Like, I haven't went to no gas stations or nothing, so I'm going to try that now. It was a little embarrassing going from painting jets to a gas station clerk. You know what I mean? So it just kind of sucked. I let my wife all out because she left me, and she took my kid, and she won't let me see him. And I'm going to get with Miss Mouton about that too, because she won't even let me see my son, and that's messing with my head real bad. So okay. I don't. Just other than that, man. Sir, I'm trying my best out here.
Give me an opportunity. Give me an opportunity to talk, sir.
Yes, sir.
Okay. In this matter, you also a review was commenced at this point back at the last hearing that you didn't file any of the paperwork to get a review. So
I don't know what, like I said, sir, I don't know what to do when it, like, do I just go to Miss Mouton to file the paperwork or? who
No,
do I-
they sent you the paperwork. You have to fill it out and return it to the front of the court's office, and then they will do a front of the court review and determine whether the amount you're paying is accurate or inflated in some way.
Okay, well, Miss Mouton, even knows, because we just talked on the phone yesterday or the day before, we still didn't have the right address even. She was sending everything to 124, it's 126.
Well, okay. That's what I was
It's
gonna ask you.
126.
What happens is you have to keep the front of the court apprised of your address.
Yes,
And
sir.
If you move from 126, as you say your address is now, if you move from there, you have to notify them so that they
Yes.
can send you the paperwork.
Yes, sir. I sure will. I promise you.
Okay. What's your education background, sir?
My education, I have GED.
GED, okay. And how have you supported yourself in the last year if you haven't worked?
My cousin, thank God, he owns this apartment building over in on 22nd Street, and I've been pretty much just staying there, and he's been allowing me to stay in an apartment that's not ready. It's not ready to be rented out to anybody. You know, it doesn't have like the everything down in it, like the water runs and stuff, but it just doesn't have everything going for it to be able to be rented out. And he's let me stay there. And other than that, just little side stuff just here and there, trying to get through to be able to get by. And he's been pretty much, my cousin's been my life right now. He's been seeing me and everything.
Okay. So you've done odd jobs. What would you say you've made on average in an average month doing odd jobs?
Oh, sir, not much. Just if I get lucky, sir. I'm not gonna lie, sir. I've been like eating out of the dumpster pretty much, man. I've been going in dumpster diving, doing all sorts of stuff to just try to survive, sir.
Okay.
I'm not
Well,
gonna lie.
that doesn't answer my question. I said, how much have
I'm
you made
sorry.
on average in a month?
Maybe $200, $300. And
Okay.
then plus my cousin, I do everything for my cousin for the building so that I can stay there. But that's just to stay there. But then now, like, he wants me out of there too, so I got to get out of there too. So I'm not even going to be staying there anymore to do that. So I'm gonna, every effort I have right now is going to be going towards getting a job, and it will be getting a job. And every effort, every waking moment of my day is going to be getting a job,
Okay.
and I will have a job pretty soon.
Anything else that you would like me to be aware of, sir?
No, sir, just besides the fact that my son is, I don't even know if he's in the hospital right now. I don't know if he's out of the hospital. I haven't talked to anybody. My probation officer kind of told me which child it was, or I wouldn't even know what child it is. And I would just like you to take that into consideration, please. And please have mercy on me and give me this opportunity to try one more time.
Okay. Well, in this matter, the court makes the following finding that Mr. Smith obviously has a support obligation in 2 cases. He's well aware of that. Again, his last payment was over a year ago, back on May 10th of 2023. He has not paid since that time. That he is seeking employment. He has not, again, participated in the GEMS program, nor did he participate in the support review that basically the court initiated in the front of the court, set up so that he could, in fact, hopefully get a job and hopefully get his support lowered, but he did not participate in that. What happens is he states that he has worked odd jobs making between $200 to $300 per month, that has been utilized to pay his living expenses as best he could. So the court will find that he has failed to exercise due diligence, failed to refuse to comply with the orders in this case, and he is in contempt of court. Anything before sentencing, sir?
No, sir.
Okay.
Just that I did try to do the program thing, and I didn't know that I was supposed to wait a couple days to call.
Yeah.
I wish I would have waited a couple days and called back. I wish I wouldn't have got sidetracked trying to do everything and trying to figure out life.
Okay. What the court will do is the court will order you back into the GEMS program. And obviously,
Thank
when
you.
you get out of jail, you'll have an opportunity to call them at that time and see about that. They will attempt to assist you in getting employment. So if you're legitimately want to be employed, they will help you do that. Court
Yes, I
will
do, sir.
also ask that Ms. Mouton would send you the paperwork again to do the front of the court review. We'll send it to the correct address, the 126.
Yes, sir.
And,
Thank you so much.
hopefully that will take care of it. What I am
Yes,
gonna
sir.
do is you have credit for 14 days served. What I'm gonna do is sentence you to 24 days in jail with credit for 14 days served. I will do a purge amount in this matter of $300 in each case for a total of $600. If you can't pay that, then you would in fact spend the additional 10 days that you have. Do you have any questions, sir?
No, sir.
Okay, you're free to go. Have a good day.
Thank you. So if I paid 600, I can still get out?
Excuse me?
You said if I pay 600, I can still get out if somebody comes with 600, like?
Yep, $600, 300 in each case. You would then be able, you wouldn't have to spend the additional 10 days.
All right, thank you so much, sir.
Okay, thank you.
Your Honor,
Yeah,
may I just let Mr. Smith know that his son Jaden was hit, but he is doing okay. I did get that
Thank you so-
notification.
Thank you so much for telling me about it.
You're
Okay.
welcome.
okay, thank you.
Thank you.
There
That's
you
all
go.
I have.
Okay, thank you, Ms. Mouton.
You're welcome.
Are you Victor Brown, sir?
Yes, sir.
Once.
Okay.
We're ready for you.
Mr. Brown, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. Do you understand the charges?
Yes, sir.
Court will advise you have a right to an attorney. The court would appoint an attorney to represent you should you desire an attorney. It's my understanding you wish to proceed without an attorney. Is that correct?
Yes, sir.
Are you doing so freely and voluntarily?
Yes, sir.
Has anyone threatened you, coerced you, used any undue influence, pressure, or promises to get you to appear without an attorney?
No.
Court will find that Mr. Brown does freely and voluntarily waive his right to an attorney. Mr. Brown, I'll have you and Ms. Platic raise your right hands, be sworn in, then we'll take some testimony.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes, sir.
Okay, Ms. Platic, you can proceed.
Thank you, Judge. We're here in docket 2006 in the matter of Lawler versus Victor Brown. Mr. Brown is here by way of bench warrant after failing to appear for an adjourned show cause on May 15th of 2024 before your honor. In this matter, this is the 8th bench warrant. He's had 9 prior show causes and 2 findings of contempt. Back in March of this year, we lowered the ordered on arrears amount down to $100 per month. So we should be paying $103.50 each month. Compliance was measured over 3 months since the time that we released him forthwith back in March at $103.50 per month. During that time, he's made no payments. Current arrearage on this matter is $3,963.31. That's as of today's date, and this is an arrears only case with the child emancipated. He was booked into Calhoun County Jail on July 11th of 2024 and does have 1 previous jail sentence for 45 days. That sentence is from March 12th of 2013. I'm sorry.
Okay. Mr. Brown, do you dispute or contest any of the statements made by Ms. Platic?
No, I don't.
Okay. Do you have any questions for Ms. Platic?
No.
What would you like to tell me, sir?
I'm going to do my best on getting that rearage paid off. I got a job lined up when I released at the new hardware store in Albion, and I do my best to get it paid.
Okay. Well, yeah, obviously you haven't paid anything previously, so you can understand how the court would be skeptical of your payments if you haven't done anything, for a considerable period of time.
Understand.
And obviously, Ms. Platic has reduced the paid upon on the arrearages so that you could, basically in this matter, $103.50 per month is not very substantial. How have you supported yourself in the last year?
I've been living with my parents and basically just helping out around here. My parents are pastors, so I've just been helping out around the church, but I've been looking for work though. I haven't had a car, but now I do have one, so I can get back and forth and everything to work. So,
okay, tell me. You said you have been looking for work. What have you done to look for work?
Been on Indeed putting in applications. I also been putting in applications at places like gas stations, McDonald's, things like that, just trying to get a job. But just haven't gotten no call back.
Okay, why do you think that you haven't been able to get employment?
I'm thinking transportation mostly, but I even put in spots where I could walk back and forth. I just haven't got a call back for some reason.
Okay. What's your education background, sir?
I got a high school diploma.
Okay.
And other than that, I did have my CDL Class A, but I had it for 6 months and then child support suspended that. That was back in 2014.
Did you have a job doing your CDL?
Yes, I did. It was Homemakers in Lansing, Michigan.
Okay, well, I will tell you, sir, that I don't think that that's I look at these and say, if you're doing something to acquire employment, do that. The court would not pull your license. So I have no problem with reinstating it if you can get, for instance, if you can get a job lined up, let Ms. Plattig know that the line, it's lined up for the CDL. I will vacate and cancel the license suspension, but you have to show us that you're going to get. I don't want to do it, and then the fact that you have nothing going on. But obviously, if you could work, that's preferable for everybody. So
yeah, that'd be best.
The court would vacate that suspension if again you have a job. So, but you have to communicate with Ms. Plattig to make sure that gets done. Okay.
All right, young.
So basically, family has just been supporting you. Have you worked any odd jobs? You've done anything like that?
No, sometimes little odd jobs come up. My dad do little side work, so I could even try to send something in even that way too. So either way, I could start sending something in.
Well, and because the amount that you owe, the $103.05 is so minimal,
right?
If you do any amount of side jobs, you should be able to pay that. And if you do, we will work with you in the event that you effectively work with us, sir.
Yes, sir.
Okay. Anything else, sir?
No.
Okay. Court will make the following finding in this case that Mr. Brown was well aware of his support obligation and that he's been had multiple involvement with the court previously. He had 2 prior contempt findings, one which he was sentenced to 45 days in jail back in 2013, that he has a minimal support obligation of $103.50, although he owes approximately $4,000 in arrears in this particular matter. He did state that he has sought out and is looking for employment in this particular case, that there should be no reason that he couldn't. He has a high school education, he has a CDL, and he should be able to acquire employment. And he hasn't done anything other than some side work that he said where he has made some money. And the money he's made on his side jobs, he should have been able to pay his support obligation if he legitimately had an interest in doing that. Court will find that he has failed to exercise due diligence, failed to refuse to comply, and he is in contempt of court. Anything you'd like to say before sentencing, sir?
No, sir.
Okay. Well, you have had a prior 45-day jail sentence. You could be sentenced up to 90 days. I'm not going to do that because I think maybe you feel that based on what you said, that you can get out and you will, in fact, comply. So I'm going to give you that opportunity. What I'm going to do is I'm going to sentence you to 24 days in jail with credit for 7 days served. Court will allow you to purge yourself of contempt by paying the sum of $500, or you will serve the remaining jail time. Do you have any questions, sir?
No, sir.
Okay. You're free to go. Hopefully you get out and you'll do what you said and start making payments, and hopefully we don't see you back.
All right. Thank you.
Have a good day, sir.
You too.
You have a good day too, Ms. Plattig.
Thank you, Judge. You as well.
Is this Mr. Holmes? Can you hear us, sir?
Yes.
Okay, we're ready for you.
Okay. Mr. Holmes, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail If it's a second or subsequent offense, up to 90 days in jail. Do you understand the charges?
Yes, sir.
Court would advise you have a right to an attorney. The court would appoint an attorney to represent you. Should you desire an attorney, it's my understanding you wish to proceed without an attorney. Is that correct?
Yes, sir.
Are you doing so freely and voluntarily?
Yes, sir.
Has anyone threatened you, coerced you, used any undue influence, pressure, or promises to get you to appear without an attorney?
No, sir.
Court will find that Mr. Holmes does freely and voluntarily waive his right to an attorney in this matter. Mr. Holmes, I'll have you and Ms. Barrington raise your right hands. We'll have you sworn in, then we'll take some. Barrington, you can proceed.
Thank you, Your Honor. We are before the court for bench warrant hearings in two matters: Shakira Boyd versus Cleveland Holmes and Mindy Arredondo versus Cleveland Holmes. After the respondent, Mr. Holmes, failed to appear for an adjourned show cause hearing on June 5th, 2024, before Your Honor. The 2008 docket is an arrears only case due to reconciliation. Mr. Holmes is ordered to pay a total of $14.50 per month. That's $11 per month towards his arrears and $3.50 for service and processing fees. The last payment received on this case was $11 on February 12th, 2024 through income withholding. This is his 7th show cause and 7th bench warrant. He has 2 previous contempt findings. I measured his compliance for the past 6 months at $14.50 per month. He should have paid $87. He paid $22, leaving a shortfall of $65. His total remaining arrears on this case as of today are $861.35. His last contempt finding was on December 7th, 2022. He was sentenced to 21 days in jail. On the 2014 docket, Mr. Holmes is ordered to pay a total of $236.50 per month, $198 for current support, $35 towards arrears, and $3.50 for service and processing fees. The last payment received on this case was $65.71 on February 12th, 2024 through income withholding. This is his 6th show cause and 7th bench warrant. He has 2 previous contempt findings. I measured his compliance for the past 6 months at $236.50 per month. He should have paid $1,419. He paid $132.04, leaving a shortfall of $1,286.96. His total arrears as of the end of June on this docket are $6,658.19. His last contempt finding was on December 7th, 2022. He was sentenced to 21 days in jail. Mr. Holmes was booked into the Calhoun County Jail on these and other matters on July 11th, 2024, resulting in credit for 13 days served. He is eligible for food assistance and Medicaid. Friend of the court would request that Mr. Holmes contact the friend of the court within 14 days of his release from incarceration and that he begin paying as ordered upon his release.
Okay, thank you. Mr. Holmes, do you contest or dispute any of the statements made by Ms. Barrington?
No, sir.
Do you have any questions for Ms. Barrington?
I believe like we pretty much talked about a lot, like which was pretty understandable, about like $92 a week, something like that, about modification and everything. But no, I don't have any problem.
Okay. What would you like to tell me, sir? How come you haven't paid since back in February of this year?
I ended up losing my job, but I still was looking for a job. I never stopped looking for a job. So the last interview I had was with the Milton, and they haven't fully finished yet to open up. So, and I was there working at Musashi. It's called Day Force. So they pay you every day, and they take child support every day. They don't do it every week. So they would take money every day. That's why the payment would be like, your last payment is $11, how it was.
Okay.
So it wasn't like I wasn't paying every month. It was like they take the money every day because you get paid every day.
Okay. When did you lose that job?
It was around March, I believe.
Okay. And what have you done since March to acquire employment?
Well, I would cut here, and that money right there I would have to use to like give them for whatever they need, the kids. Like if they needed shoes or anything. That's how I was surviving. And I was surviving staying with my grandmother.
Okay. Well, my question was, what have you done since that you lost that job back on March? What have you done to
Well, I've been
acquire
looking
employment
for
since then?
work. I've been looking for work.
Okay, what have you been doing looking for work?
Well, I will go to temp agencies that I worked for before, and I will call them. And then I eventually started going to restaurants, filling out applications for them. But like the program that she was telling me about, I think that would be a good fit because then I could get certificates for a job that I would like, that I would be able to work long term.
Okay,
It's called the GIMS program.
yeah. How many applications have you put in since March?
Let's see, I want to let's see, probably about a good 20. And then I will follow up with the temp agencies I work for. And a lot of the temp agencies right now for the industry and the factory industry out there in Fort Custer, they have like a hiring freeze.
Okay, I didn't hear how many apps have you put in?
At least 25.
Okay. Why do you think that you haven't been able to be employed?
Well, I have a bad record. And then like the last felonies I caught, they were R&Os. They're not 3 years old yet.
Okay.
So that's why I end up start putting in applications for fast food because fast food don't look too much at your record like that.
How have you supported yourself since March?
I will cut here and my grandma helps me.
Okay, what would you say? How much are you working odd jobs? How much do you make on average per month?
Per month, let's see, I probably would get by with like, it depends on how many haircuts people will ask for like an odd job. So I could probably run across at least $300 per month.
Okay.
Because I help people move like odd jobs.
And that money that you've made per month, why haven't you paid some towards the support obligations, even if you couldn't pay them in full?
Because I would help my kids with what they need and their mothers with what they need. And plus, like, until I got the GIMS paper, I didn't know that you can go to like Family Dollar and places like that and pay your child support. I would have been going to places like that doing that if I would have knew I could do that. I didn't know you could do that.
Okay. Anything else you'd like me to be aware of, sir?
Yes, sir, that I'm going to be here to the 7th of August.
Okay. Okay. Court will make the following finding in this case that Mr. Holmes does have two cases that obviously he's well aware of in this matter, having had numerous show cause, bench warrants, and a finding of contempt on two different occasions. The last being in December of 2023, where he was sentenced to 21 days in jail. That he lost his job in March of 2024. He has stated he has been attempting to put in applications. He's put in 25 since that time. I will tell you, sir, you could put in 25 applications within a matter of a few days. Yes, sir.
Yes, in the contempt of courts, like my address, it was never really up to date all the time. So I would miss a lot of them. Like the last time I had when I called and they adjourned it, they had the Zoom. I really didn't know how to do the Zoom. So I went downstairs and I talked to the man and he was going to give me enough time, but I ended up getting incarcerated to pay him $400.
Well, what you have to do is if you have moved or anything like that, you have to change your address with the front of the court so that they have to be able to send the paperwork to you.
Yes, I never moved though. That was the thing. But I didn't know you had to call every month to still update your address. So I know now.
Okay. Well, in this matter, as I said, you could make you could put in 25 applications within a couple days. So I'm not but
I would do it on Indeed. I'm just saying that would be the least I could remember. I would be on Indeed every day putting in applications.
Okay. Well, when I asked about application, you just said 25 since March.
I'm just saying that would be the least. I'm sorry.
Well, regardless, it doesn't appear that you've put in a substantial amount in this matter. You stated that you do have some felonies, but notwithstanding that, you stated, you do cut hair and have odd jobs where you make about $300 per month in this matter. So you did have the ability to make payments towards your support obligations. The court will find that you've not exercised due diligence, you fail or refuse to comply, and then therefore you are in contempt of court. Anything before sentencing, sir?
I was just like, I tried to do the best I could. Like, I still took care of my kids. Like, it's hard to do both at the same time. Like, if they need shoes or they need anything for activity and their mothers need help, I was obligated to try and help in that era. And I failed. I can't fail in one part and then be correct in both parts. So I failed in one part.
Okay, well, obviously, if you're not paying your support obligation, then you're not taking care of your kids, because that goes to pay the custodial parent to support the kids and pay for all the expenses of raising the kids. So what the court's going to do is the court is going to, I could sentence you up to 90 days in jail. I'm not going to do that. Hopefully, I'd like you to get out and get a job. What the court's going to do is I'm going to sentence you to 30 days in jail with credit for 13 days served. I will allow you to purge yourself of contempt by paying on the 2008 case the sum of $200, and on the 2014 case the sum of $500. If you pay that, then you wouldn't have to serve the remaining time. The court will also order that when you are released, that you would participate in the GEMS program, and they will help and assist you in acquiring employment. Do you have any questions, sir?
No, sir. I appreciate being able to participate in the GEMS program.
Okay. That'll be the order of the court. You're free to go. Have a good day, sir.
Okay, thank you.
Ms. Barrington, anything else?
One correction for the record, Your Honor.
Okay.
In the matter of docket 2000 involving Devontae Lewis, we previously requested a bench warrant in this matter. However, a friend of the court would like to withdraw that request for a bench warrant and request that the $500 bond posted be forfeit and applied not only to the arrears balance on the docket, but also the $150 court cost balance, with then any remaining money being refunded to the respondent. And that will pay this docket up to date. Therefore, a friend of the court requests that this action be dismissed.
Okay. Court will forfeit the bond previously posted by Mr. Lewis in this matter. They'll basically apply that towards the arrears and then to the court cost of $150. Any balance would be remitted to the remitter of that particular money. We will then dismiss the action. And again, I'll recall the bench warrant.
Thank you so much, Your Honor. That is all for me.
Thank you.
Have a good day.